when they used to do those, I'll say god awful, RJ anonymous survey things, in this humble court's opinion, overly broad and poorly worded rule 48.1 subsection 9. Thank you for your patience. Our other 1030 matter, State of Nevada versus Snap Inc. Let's go ahead and have argument on that. So many pieces.
Morning, Your Honor. Randall Jones on behalf of State of Nevada.
Good morning, Mr. Jones.
Good morning, Your Honor. Michael Gayan, also on behalf of the State of Nevada, and on the Zoom observing only, we have our co-counsel Phil Carlson, who I believe is pro hoc in this case, and then others from his firm observing: Matt Bush, Naomi St. Soom, and Sydney Jane.
It says they're all observing. Is that correct?
That's right.
The only person who is listed here not observing is Daniel Downs.
Yeah, I'm not sure who that is.
And then Samantha Feely, Senior Deputy Attorney General with the State of Nevada.
Okay, welcome to all of you.
Good morning, Your Honor. Alex Fugazi on behalf of defendant Snap Inc.
Do you know who Mr. Downs is?
I do not, Your Honor.
Do we know who Mr. Downs is? I have no problem with observers. Somebody could be sitting in the courtroom just as well. I just wanted to make sure, because generally when I have people who are observing, I just want to make sure, and I typically would check in to make sure that they can hear everything. And I know that they'll know if they can't hear everything, that they let us know in the chat, but.
So he put from our Nevada judges here to record.
Fine, perfect. Yeah, I just wasn't sure who that person was, and wanting to make sure that everybody could hear us. And again, inviting anyone who's observing us on Zoom, that if something happens, you cannot hear us, something changes, please, by all means, send a chat in. Our recorder is monitoring that, and we will stop and we will make sure that we fix that connection. Otherwise, this is the show cause hearing that the court set on peremptory challenge, and the concern that the court had in reviewing the record when it received the case following the exercise by Snap Inc. of a peremptory challenge, its first, that caused the case to transfer from Department 24 to Department 25. In going back and simply reviewing the record to get up to speed, because there was a motion to dismiss that was imminent to need to be set and heard, the court determined that there had been 2 peremptory challenges exercised by the State of Nevada, and had concern that possibly the second exercise of that peremptory challenge was in violation of Supreme Court Rule 48.1 subsection 9. And if so, then would potentially require the case to not have been reassigned to this department. And I think the natural outcome, should the court determine that this was an errant second peremptory, might result in the case being returned to Judge Reynolds. But that's sort of talk about putting the cart before the horse. The real issue is, and the court, I just want to be clear. I have no problem, obviously, with this case being in this department and staying the judge on this case, should it have been properly reassigned here. What I'm trying to make a record of, and I'm trying to address, and I'm interested to the extent that the state will have some specific information to provide on this, is it seems to be happening. Sorry, did you need to?
Sorry. Well, Your Honor, I just wanted to make sure you got a courtesy copy of our response that we filed last Thursday.
Oh yeah, we have that.
Okay, great.
Yeah, we didn't need the courtesy copy. It's in the case, and I definitely reviewed it.
Great.
I noticed that the defendant did not respond in any way, and I didn't anticipate they would, but just to confirm, Mr. Fugazi, you didn't have anything, right?
We did not, Your Honor.
Okay, thank you. So yes, we saw your written response. I'm just giving sort of some of this background so you understand, where we're coming from here. But there has been an ongoing sort of, lack of better word, debate amongst the court administration judges as to circumstances of counsel making determinations that they think their case belongs in business court, designating it for business court, it arguably not belonging in business court even upon that request, but doing that because that puts it in the realm of basically currently 6 assigned judges, of whom 1 of 6 will be randomly assigned, who have arguably lengthy civil practice backgrounds and expertise, and that's why they're assigned to business court. And then utilizing that as a way to, I'm not saying this is what occurred here, but effectively preempt 26 other judges without actually having to file a preemption or otherwise doing that. And then, it is incumbent under the rules for the business court judge to make the determination, was that a proper designation? Did it properly belong there? And if not, to redesignate, which is what Judge Johnson did in this case, following the preemption that was exercised by the state for Judge Denton. And so I think there's several things at play here. There's how did we come to be in business court to begin with? I understand in your filed response, you indicate that you believe it belongs in business court and that Judge Johnson is in error in her decision making, but you weren't fighting it at that time. So we may have to address that. But at the end of the day, I think what really boils down here is, was this a reassignment that was contemplated by 48.1 subsection 9 and would trigger then a second preempt for the state? Or was this in fact something other than that, that basically caused the transfer of the case more properly to a non-business court judge? And because of the, prior preemption of Judge Denton, obviously it isn't something that could have been sent back to the original assigned judge in that case, because it was originally designated business court. Then you got a business court judge, then you preempted that business court judge. Then the judge who got it determined it didn't belong in business court, so it was reassigned or ultimately transferred for that reason. Is there in fact a second bite at the apple for the state in that regard? So, lots of seem to be moving parts here, but at the end of the day, Mr. Jones, I welcome you here to address it however you see fit.
Do my best, Your Honor.
Okay, so you're right. This has kind of a bit of a tortured history, the way it all bounced around and things. I want to address the business court issue first, because I understand, and by the way, this as a result of Judge Johnson's sending the case back for reassignment. We have looked at that issue pretty closely, and also as a result of that, we started to hear that there's some concern, not just with Judge Johnson, but it was a deeper concern in the Judicial District Court that the designation of a business court case was being overused, or in even some cases potentially abused. And so I want to say now for the record and make sure it's clear to this court, we thought, and we still think, and we didn't challenge her decision about that issue under 16 or 1.61, but we and I've known Judge Johnson. She went to high school with my younger brother, so it was one of those kind of situations. So I've known her for a long time, and I have great respect for her. I've tried some significant, I think the longest case I ever tried was in front of her, 5.5 months. So I know her well. While we disagreed with her, the reason we disagreed is we designated business court in that case, I think specifically referred to the complex nature of the case under the subsections under 1.61. However, that isn't the only reason, and we didn't get into a fight over this, but there's also, we believe that business torts would apply to these cases that we have filed, these social media cases, because as you probably know, this is not the only one that's over here, and maybe you don't, but
No, I'm aware Judge Kishner has the other 4 entities,
right.
I believe, in a case, and has maintained those as a business court case.
And the reason, one of the reasons I bring that up is because when we were in front of Judge Kishner, I think it was even last week, we were anticipating, in light of what happened with Judge Johnson, that she might bring this issue up too and say, hey, wait, now that I think about this, maybe Judge Johnson is correct. And we were prepared to make that argument to her, but she on her own brought it up and said, I understand what happened with Judge Johnson. I take a different view. I think this is an appropriate case for business court, and I'm not going to reassign it. So
Interesting.
I know.
I had a different conversation with Judge Kishner, but it doesn't matter what conversation I have with Judge Kishner, because at the end of the day, she makes the ruling she makes in her courtroom, but I had a very different conversation with Judge
Well, that
Kishner.
isn't, because this was on the record, and Michael, did I misstate that? That was
I'm not doubting you. I understood she was keeping the case. I did not understand she was keeping the case because of a belief that it belonged in business court.
And
I
maybe-
don't, yeah, just to be clear, I don't recall that specific discussion, but we have had many substantive hearings and it's never come up. And I understand she is keeping the case.
And I just want to be perfectly clear, Mr. Jones, I have no doubt she might have said that. I'm not questioning that.
Well,
I'm saying in a moment, in a discussion that's not obviously going to be carrying the day in any particular record, I'm going to be candid that I made the comment about, I don't personally, I believe Judge Johnson was correct in her assessment that it did not belong in business court. And I understood Judge Kishner to agree with me.
and by
So
the way,
again, passing conversation.
as you made your point, I'm thinking about this. I don't know if she went to the next step. Maybe in my mind, I thought to myself, well, that means that she disagrees with Judge Johnson. I don't know if she actually said that. Now I think about it. And maybe she did. I just don't remember. I do know she said, I'm keeping the case. I
She's
do
keeping
remember
the
this.
case, and I had every reason to believe that she was keeping the case.
So with that said, in any event, the reason we believe that we are entitled to this additional preemptory challenge is based on the plain language of the rule itself, meaning 48.1 and 0.1 subsection 9. And I'm just for the record, where it says, quote, notwithstanding the prior exercise of preemptory challenge, in the event that the action is reassigned for any reason other than the exercise of a preemptory challenge, each side shall be entitled as a matter of right to an additional preemptory challenge, end quote. So on page, I think it's on page 3, line 2 of her order on August 5th of 2024, Judge Johnson specifically says, I am reassigning this case. So that would be.
She did use the word reassignment. I will tell you, because might as well, I'm trying to be perfectly candid here. I did have a conversation with Judge Johnson, and she is of the opinion that it was improperly designated originally, of course, because that's her order, but she's also of the opinion that there would not have been a second peremptory available based on her declassification, even though she used the word reassignment. But again, those things don't matter. What matters is Judge Kishner kept her case, and the question is, am I keeping this one? And my sole basis for my decision on this one is going to be, did you have a second peremptory or not? And so I understand, and I do want to focus on the plain language of the rule, but I also want to focus on the state's citation to the Reggio case.
Yes.
Because I think that opens the door to some question about how plain that language is of 48.1 subsection 9.
And obviously we cited it, the court, I know has read it just because of your practice. So I can quote that. I mean, the point as I get from that case is, and obviously it doesn't, in that case, they said you didn't get the second bite because of the consolidation issue, which we don't have here.
Right.
So this
Definitely
was,
don't have that here.
this is the initial action. It's the only action that's relevant to this particular discussion. So it's the only case at issue. It was it was not subject of a, excuse me. I had that on, thank you. I had that
It's okay.
on mute, but apparently.
Mine does it more often than I want to admit.
So, I mean, the language to me, reading again, on page, this is from the case, where I'm quoting in, on the.
I just have the Pacific site page numbers. Is that what you can give me?
If I have them right, this is.
Because I still have a copy, advanced opinion copy, so I don't have anything other than Pacific.
This is on the, I think it's the last page of the opinion. It's a paragraph that starts, we adopted Supreme Court Rule 48.1 in 19.
I'm there. I'm there.
Okay, so if you go down past the citation there, it says, quote, we added subsection 9 in response to elections, retirements, and anticipated addition of new district judge departments because it will become necessary for the district court clerks to reassign civil division and family division cases. It goes on to say, and I think this is the most important part the holding as it relates to this issue today, Your Honor, is saying, quote, it furnishes a party with an additional preemptory challenge as a matter of right, even if the party previously exercised a preemptory challenge under Supreme Court Rule 48.1, subsection 1, in the event that the action is reassigned for any reason other than the exercise of a preemptory challenge, and then cites again subsection 9 of 48.1. And I don't know how, I guess from my perspective, if you read this literally and you look at literally what Judge Johnson did, she reassigned the case to a non-business court department. That was a decision or a reason other than preemptory challenge. So, for example, if you take the analogy or the circumstance, let's just say Judge Denton, who had the case originally, and we exercised a preemptory challenge, and he said, well, it doesn't matter because I'm reassigning this case because I don't believe that this case should properly be in district court. Well, what would happen? We would get another preemptory challenge as far as I could see, because he's saying that preemptory challenge has no effect on me because I'm going to reassign it because I don't have jurisdiction. So I don't even, from my perspective, the issue of the preemptory challenge becomes a nullity under both EDRC 1.61 and Supreme Court Rule 48.1. That's as if, so it didn't matter whether it was Judge Johnson or Judge Denton. It was reassigned for a different reason. The reason being that Judge Denton and Judge Johnson, according to her, neither one of them had jurisdiction over the case to begin with. So, and I'm just looking at the literal language. I mean, otherwise, how do you, she didn't reassign it because we improperly used a preemptory challenge. And the rule specifically says if it's any other reason, as a matter of right, you get it.
There are a couple things, but I want to unpack a lot of what you just mentioned.
Okay.
First, I want to point out that in the Reggio case, that last part that talks about the action is reassigned for any reason, it's literally quoting the rule. It's not separately holding that there. It's just literally quoting the rule.
Yeah, no, and I agree with that.
That's just
Yeah.
one thing I want to point out. I won't let you finish with Mr. Gayan, but.
Yeah.
But here's the sort of, I guess the point that I want to make is I very, maybe not so artfully, but intentionally worded my order to show cause to say, is it the case that the matter was the state's exercise of a second peremptory challenge following a change in case designation and subsequent reassignment due to the state's exercise of a first peremptory challenge? I guess my point is, let's assume, just for this hypothetical, that the case was improperly designated to business court, and had it been designated properly and gone to a non-business court judge, arguably it could have landed with Judge Denton even then, but it had been assigned to a non-business court judge initially. Okay. And you had asked subsequent, because this happens all the time, for transfer over to business court.
Mhm.
I have learned, and that has occurred, and I have a specific example of a case that I dealt with a few years ago, where it was assigned to me. It was identified to me as existing out there in the world because we don't lurk on our filings and know what's out there, I promise you, until something, shows up on our docket. But the PIO referred me to it because it was getting a lot of media attention when it first got filed. So I looked at it. And as I'm looking at it, I realized the plaintiff didn't seek business court, but the defendant, in responding and filing an answer, sought business court, but it had not transferred. So I reached out to the clerk's office and I was like, this hasn't transferred. Is that because you, as the clerk's office, realized it did not belong in business court, so you didn't transfer it? Or is this just a miss? And the clerk's office was very clear. That's just a miss because we don't ask. If somebody says they want business court, it goes into business court and it is 100% for the business court judge to kick it back out again. I don't think most business court judges, and when I had my tenure on the business court off and on over many years, I did not sua sponte go look at something and say, this doesn't belong in business court. If a party challenged it, and that's what happened in the other case, it did go over to business court. It was assigned to the Honorable Nancy Alf at the time. And she reviewed it and she ultimately said, if the parties challenge it, then I'll review it. Otherwise, I'm leaving it. And that's what happened. It stayed there and it's now been since transferred to Judge Hardy on her retirement. Doesn't matter what case it is. But my point is had it been filed as a non-business court, and then one of the parties asked for it to transfer to business court and Judge Johnson had done the review of what occurred, and she de-designated it as business court, it would have gone right back to the judge it was originally assigned to. It wouldn't have been a peremptory issue. But the reason when she de-designated it, that it couldn't go back to the judge it was originally assigned to, was because it was improperly, according to Judge Johnson, designated as business court to begin with, got assigned to Judge Denton. You then exercise your peremptory challenge of Judge Denton. So when she de-designates it, there's no choice but to reassign it to another judge. So is that not an occasion of your first peremptory being the reason why it had to go to a new judge and not back to the original judge assigned?
Well, I guess there's a couple of things I could say there. One is that in that scenario, if it goes back to the original judge, then the preemptory challenge would not have been exercised, right? Because it would have been moot if it goes back to that judge. So presumably then you would have that preemptory challenge back, it would just go to a different judge.
Yes, you
A
would have
different
still had a peremptory challenge available to you. But you wanted business court, you got business court, you didn't want the business court judge you got, so you preempted.
Mhm.
Once it's de-designated out of business court, it has to go somewhere, but isn't it the result of your original preemption as to why it's going somewhere else and not back to the original?
Well,
Judge.
I guess the first thing I would say, and you made a point that it's true. We did not challenge her decision on business court, and obviously you've talked to Judge Kitchener about what was in her mind when she kept, for whatever reason.
No, I
she kept
haven't.
those.
I just had a very passing conversation where I said, yeah, I've got that snap case and Judge Johnson de-designated for business court, I don't see how it belongs to business court. And my understanding of the response was agreement with Judge Johnson's thought. Not any beyond that. We were in a meeting that something else was going on in. I'm not bringing it up because it has any relevancy or potency or should be repeated as anything substantive in any other thing. It is 100% her decision whether she keeps her case or not. But my point was, I was just surprised to hear you say that she disagreed with Judge Johnson, because that was not my understanding of our very limited conversation.
I understand. So I certainly, again, that's the second time with two different judges, I'm reading more into it than what they intended. But be that as it may, here was what the point I was really trying to make is, because we didn't dispute Judge Johnson's decision that it's not a business court case, we never had the opportunity to make the argument to her, to brief it and to tell her why we think she was wrong, and maybe she would have still disagreed with us. And if we had that conversation or that discussion with Judge Kitchener and say she decided, well, I'm reconsidering that, I would want to rebrief it, because I think there are specific provisions of 1.61 that we do believe, separate and apart from the one we've used forever in our firm and never had a challenge before. That's why we have these. I don't think anybody can dispute this is a complex case.
There's literally nothing in the rule that indicates that because it's a complex case, it can go to business court. That is not how business court assignments are made. So I understand if your firm has looked at it that way. I would respectfully suggest to you that, again, the reason why no one may have up to this point, if you asked for business court, for whatever reason you chose to ask for business court, didn't kick it back, is because it just hasn't been the practice of business court to sua sponte review upon receipt and kick cases back. It has been the practice of business court to allow the other side, if they challenge that request, to do so, and then to make the analysis. But I was present when, basically, not when business court was created, let's be clear about that. Judge Porter had that assignment early on, but I was very early in my tenure with Judges Gonzalez and Denton. as the business court 3 assigned judges for several years until I was asked by the court administration to take on a very different role on the criminal side of the house. But at the end of the day, many discussions had with Judge Gonzalez and Judge Denton and myself about what belongs in business court, what doesn't belong in business court, and how the rule should be interpreted and how we should apply the rule if there is a request or a challenge. So respectfully, case complexity is not a basis to get business court. But you mentioned the one that I think perhaps would fall potentially in your case is business torts. You mentioned business torts.
And by the way, you, as a result of this conversation, it refreshed my memory that I misspoke. It's not in the rule, this complexity. It's in the form that we have to sign when we file a case. And that's one of the things.
The case, the what do they call it?
So
Civil
it
cover
has-
sheet. Yeah, we've heard about that.
So it has no legal weight, but that is what we sort of ticked off because it was one of the things listed there. But you're right, we have to file what's actually in the rule as opposed to what's on a form that somebody in the clerk's office may have put together. So I stand corrected.
But
on
you
that.
mentioned business torts and you do have deceptive trade if that would qualify, and you've got some other references. So if you want to make that link, you can. This is such a helpful record to make whatever the outcome here is today, because what's in play here is this bigger picture, which is a percolating issue right now. I will be candid, based on Judge Johnson's decision, not only in this case, but based on communications amongst the judges about how we should be handling designations by counsel for business court cases where, you know, the elephant in the room is, I'm not saying this firm is doing that or that the state would do that, but that there are, you know, it is sort of not a well-kept secret that there are firms that want to be in business court because they want the experienced civil judges, and they're putting it in there, and they believe, I disagree, and I believe my colleagues disagree, they believe that the court is complicit in allowing that to happen because of the higher filing fees and happy to just take those fees and turn a blind eye. I disagree. I don't think that's the case. I think what has been the case since Judge Gonzalez sort of developed business court as it currently sits today, and then ultimately when it expanded beyond 3 judges to 4 for quite a while and now up to 6, which I don't think was ever intended by the business court, in fact. But at the end of the day, that it is intended to be business court appropriate cases should come to business court experienced judges. And then you have the ability to preempt within that smaller group, and that's understood. But the use of coming to business court when it's not a business court case, and again, effectively preempting 26 judges without having to ever make a peremptory, that is something that's sort of an underpinning, not going to decide this matter today, but an underpinning issue that's out there. The other underpinning issue is that rule for 48.1 subsection 9 far too broadly worded in the way that it's worded. And I would argue if I do ultimately make the determination today that you had a second preempt, then it would be because of the broadest view of that wording. And perhaps that is something that needs to be revisited in the rulemaking process. But
And I appreciate all those points, Your Honor. And I hear what you're saying and you all on the bench side of this discussion are seeing what's actually happening. We all, and I appreciate you saying that you don't think we would do that. And I can assure you on the record, even though I don't think you necessarily need me to say this, but I will say it. I think it's important. We do a lot of complex civil litigation as Gazi's firm. And so we typically make very conscious choices. If we have a PI case, a personal injury case, it is a car accident case, you know, we're typically not going to file that in a business court setting, but unless there's something very unique that somehow or other gets to business tort type issues. But and clearly the state of Nevada, we don't believe would ever be complicit in something like that intentionally either. So our clients. So with that said, it doesn't mean that people aren't taking advantage of it. And obviously the business court judges are feeling the brunt of that, and they're having to take on an additional load of work that they probably shouldn't be taking on. So I understand the policy reason behind this. I can assure you that had we been given the opportunity or felt it necessary to take the opportunity to clarify our position and why we thought we were appropriately in business court, we would have done so.
And you still have the position today that you believe you are appropriately in business court,
And again, we haven't fully briefed it, so I'm.
but
just
based
going-
on the business tort.
I'm talking off the top of my head because we had sort of, I would have probably been better positioned to argue this last week because I've been more prepared for that, depending on what Judge Kishner said after our first hearing, or after the first, the hearing we had after Judge Johnson did what she did. So, I certainly can't fully expand on that and cite any other case law that might give you some direction or us direction, whether right or wrong. We certainly believed then, and we believe now. And we are potentially going to file additional cases for the state of Nevada, all of which, depending on what goes on here, because I would think that we would want to, because I've been in front of, there's many, as you said, 26 other judges in this court, some of whom would not take the case under any circumstance because they're assigned to criminal only. But there are plenty that are not.
3 of those right now that I think are all criminal.
So
Maybe only 1 now. Sorry, I think there's only 1 that's all criminal
I
now.
thought it was,
Judge
I
Levitt.
thought it was 3 or 4, but
There
in
were
any
4
event.
originally when the homicide team was created, but in recent developments, 3 of the 4 went to a split docket.
So in any event, our position has been and will continue to be until the court tells us, look, we've looked at this issue and specifically at that issue, which has been briefed. And we've looked at the law as we interpret it, and we either agree with the state's position or we disagree. But that continues to be our position, and I think we take that position in good faith, Your Honor. So, and the other point I would make is in the holding itself.
Let's return to the rule when you're ready, but go ahead.
Yeah, in the Reggio case on the first page of the opinion, it's in the head notes 3 and 4, it says, quote, further, parties are entitled to an additional preemptory challenge under Supreme Court Rule 48.1 subsection 9, if their case is reassigned. And then it goes on and talks about the consolidation issue, but then at the very bottom, and this is not just quoting the rule, this is what I believe to be a specific holding of the case. Towards the bottom, it says, consequently, parties in consolidated cases are entitled to an additional preemptory challenge under Supreme Court Rule 48.1 subsection 9, only if the first case is reassigned, not when the second case is transferred to be heard but from the first. So by implication then, if it is not a consolidated case where the first case was not reassigned, then you're going to have a 1 preemptory. That's all you get. So I believe that the Reggio case is telling us that you do have a right to a second preemptory as a matter of right, if for any other reason, the case is reassigned as opposed to the preemptory. And I get your point about you got to go back, but I still, the reason that she reassigned it, and presumably if Judge Jenton would have had the opportunity to do so, then he would have, if you're telling me what it sounds like, there seems to be somewhat of a consensus among the district court judges that a case like this should not have been in the business court, then why wouldn't Judge Denton have done the same thing? In which case we clearly would have been entitled to a preemptory.
Well, Judge didn't know it was there. He got preempted, as far as I know. Like, I don't think he had actively been involved in the case, but I could be.
Well, my point, I guess, is if Judge Denton would have reassigned the case because it should have worked before we exercise a preemptory.
I guess my point is, I don't think he knew the case was there to do that.
No, I don't think he did either. No, it was done too early on for him to give him that opportunity.
Setting aside the first aspect of sort of how I challenged this and the way I wrote up the order show cause to say, is it not somehow tied to your original preemptory that when Judge Johnson designated the case business court, that's why it had to go somewhere else, and ultimately that is then a reassignment based on a prior preemptory. Setting that aside, I appreciate that's the weaker, I think, of my 2 concerns. The real concern that I have, or the additional concern that I have, and maybe the stronger, I think, of the concerns, is tied to the Reggio case, because I honestly don't understand how in the Reggio case it can quote, as it does, this very broad rule that says, in the event the action's reassigned for any reason other than the exercise of a preemptory challenge, and then not apply it even if it was a consolidated case. I mean, if it's that broad, if it's any other reason but peremptory, you get another bite at the apple. How on earth could they not give another bite at the apple when the case was consolidated? Because it's being transferred and or reassigned, whatever terminology you want to use. I say de-designated. Judge Johnson said reassign. There's the use of the word transfer, whatever. But the bottom line is it's new assignment. It's moved from case 2 to case 1, had nothing to do with a peremptory challenge. So why is there not a second bite at that apple? Doesn't the Reggio holding itself stand for the proposition that there can be other reasons besides peremptory challenge for which you would be precluded from having a second peremptory challenge?
So, Mr. Gayan, my partner I've got one point I'd like to make on that issue.
Any
But
point you wanna
but the
make, go
other
ahead.
one that Mr. Gayan just pointed out is below the paragraph we cite on the last page of the opinion, the last paragraph on the left-hand side of the page, it says,
If you're looking at head notes, I don't have them.
let me.
Give me
third-
a Pacific Third
It-
citation.
It says the issue here is not the definition of reassigned. Let's get to the page number. I can't.
I see it.
Oh,
It's
I'm sorry,
356.
356, I see it.
Three
Go ahead.
fifty-six or 357?
No, it's 356, 357 kicks in the next paragraph.
I
Go
got
ahead.
it. Thank you. The issue here is not the definition of reassign, but whether Supreme Court Rule 48.1 sub 1, description of a quote unquote action, which is that quote, each action, whether single or consolidated, shall be treated as having only two sides, end quote, applies to an quote action, end quote, under Supreme Court Rule 48.1 subsection 9. So I think that at least as I read this, the Supreme Court addressed the very question you just asked. And based on the definition of a consolidated action, the second action that was filed that got consolidated with the first action simply doesn't exist as a separate action. Because if you're consolidating, there only ever is a fiction, a legal fiction. But it becomes the only action that there ever was or ever can be is the original action. And if you've exercised the preemptory there, then you're done. That's not the case here.
Even though they go on to point out that there are other times and places where it's still two cases, et cetera, et cetera. But the point is, in the next paragraph down where it crosses over into Pacific Third pinpoint site 357, it talks about they are trying to read 48.1 subsection 1 and 48.1 subsection 9 in harmony. And in so doing, they're basically focusing instead on how they read consolidation and what it means, and respectfully not addressing 48.1 subsection 9 at all, in my opinion, because the way to read those things in harmony, I think, could be, not saying again, I have the utmost respect for all of my colleagues on the appellate court, but if you're going to read them in harmony, you have, consolidation is consolidation, action is action. That's fine. We have an action when you consolidate. But at the end of the day, if the change in judge to the parties occurred because of any reason other than peremptory challenge, there should be another peremptory challenge. So the way to read them in harmony to me would have been could give the additional peremptory challenge. But even if they struck that court differently, I think you could look at Reggio as saying, as I put it earlier, can there be ways in which a change of judge occurs that do not implicate a new peremptory challenge because they're not they're definitely not based on a peremptory challenge reassignment, but they're not technically a reassignment. I mean, the other piece of Reggio that speaks to this to me very clearly, and again, I think is sort of not fully engaged with by the Supreme Court in the Reggio case, is when you go look at that 80 KT 434, the petition, the April 13th, 2009, how they came about deciding this and to include this subsection 9, they talk about it, but they don't really speak to it, which is the whole reason subsection 9 exists is to deal with when the court chooses or needs to reassign cases because a judge retires, a new judge is elected, we have to reassign cases between, in this case, it referenced civil and family. But other reasons why the court does its shuffle up because new judges come around, or like I mentioned in the former 4 judges that were all homicide and criminal, who then wanted to have civil dockets. Now 3 of them have half civil, half criminal, half homicide, half civil technically. And that's the court saying, I'm reassigning the case. And guess what, you guys, you didn't have a say. So yeah, you should get a second bite of the apple. But when it happens for reasons that have nothing to do with the court's administration, new elections, retirements, additions of new district court judge departments, the things that prompted 48.1 subsection 9, is this not a case that had nothing to do with those things? This was not a court reassignment because of any of those reasons. This was solely a business court judge saying, you know what, this case does not belong in business court, so it needs to not be here. She could have arguably put in her order, I'll keep it as a non-business court judge and de-designate it and make it a B and a C instead of a B, and held it, but she didn't. And okay, her choice. Is that the final decision maker here? Is because she chose to not keep it as a C and instead ask the clerk's office to reassign it randomly? Is that what triggers the rule because of its broad language? Or should we look at this as this had nothing to do with court administration undertaking reassignments that in fairness should invest the parties with another parent? I don't know if you want to speak to that.
Sure, I think that you mentioned, and the court gave us some hypotheticals, as you mentioned, retirement of a judge and those kind of things. That there were, I certainly didn't get from the Supreme Court that was to be an exhaustive list, and I think they even said et cetera. I can't remember off the top of my head, but I think they made a list of a few things.
There could be other reasons, but these were, let's put them all under the umbrella of court administrative changes.
And I think the ones that are referenced certainly would fall into that category, but I don't know, especially when I read the language. So if I fall back to Supreme Court directives to the district courts that, look, you read the statute based on its plain language, plain and ambiguous language, and unless there's an ambiguity, and it sounds like you're seeing, based at least again, my understanding or interpretation of what you're saying is you're seeing an ambiguity here that I'm actually not seeing, and I think the language of the rule is unambiguous. I think the language of the Supreme Court in the Reggio case is unambiguous, and it says, and because we could come up theoretically, we could come up with all kinds of additional hypotheticals that may or may not apply.
Probably could.
And so the difficulty I have as a practicing lawyer is what I feel I am required to go by, and unless there is an ambiguity, then I can argue all day long about things. I don't see the ambiguity here that clearly the court seems to see.
I don't, let's be clear, I don't see an ambiguity in the rule. My problem is the rule isn't ambiguous and it's far too broad, in my opinion, because it says any reason other than peremptory challenge, rather than saying you can have a second, bite at the apple if the court for administrative purposes reassigns or something along those lines. It makes it has to be anything other than peremptory. What I'm concerned with in the Reggio case is in the Reggio case itself, here's an exact case where it wasn't reassigned for peremptory challenge purposes, yet they denied the second peremptory. They cite to the rulemaking process, which explained that it was 100% supposed to be court administrative reassignment's purpose for the creation of the rule. And yet in the end of the day, they said, sorry, consolidated case, no additional peremptory for you, which begs the question, if it's reassigned or transferred or otherwise gets a new judge, let's just say that, for reasons that were not peremptory challenge based, but at the end of the day, not court administrative shuffling around, should you get a second bite at the apple?
And I'll go back to an argument I made earlier, which doesn't sound like it's resonating too much, but the way I look at it and the way I think that the court looked at it is because this consolidation issue is Reggio. So it's a different factual scenario than we have here. But the way I read the Reggio case is you don't even look at the second case because there's another rule that takes precedent in this circumstances. In other words, if you're gonna put these things in sort of a chronological order.
Yeah.
We need to look at, see, okay, does this second case, is it a second case? Or is it really just the first case? And if it's the first case, you already got your bite at the apple. If it is a second case with a second judge that is going to stay there, and in this case, there's no doubt, it's either gonna be you or it's gonna be Judge Reynolds. It's not gonna be Judge Denton, and it's not gonna be Judge Johnson. So
Or Judge
if I read Reggio as being intellectually consistent, then you have to say there's a new judge. It's never gonna go back to Judge Denton at this point, never. It's never gonna go back to Judge Johnson at this point because of their preemptory challenge. So at this point, I think if you read the various rules that are supported or cited by the Supreme Court in the appropriate order as they've laid them out, you can only come to one conclusion if you follow the literal language, of the rule. And I don't think, and you're the judge, and so you get to make this call, that a district court has a latitude. And by the way, I have seen other district court judges in my many years of practice, and Judge Gonzalez is a good example, of look at a rule and say, on the record, this is a dumb rule. This rule is poorly written. And yet she is forced to follow that dumb rule. And many times, by the way, I've been the one agreeing with her, but she had to do what the rule said she had to do in spite of the fact, because I don't disagree with your point. I think every point you've made makes logical sense. But if I revert back to what I understand as a practicing lawyer, I'm supposed to follow. The rule says we get a second preemptory challenge.
Yeah, we don't have any competing rule here or competing statute here like they had in the Reggio case, that's for sure. My gripe about the Reggio case is all of it sets up to be, this is why the rule exists, which would not arguably be applicable here. Here's a case where it wasn't a peremptory challenge that caused the reassignment, but yet we're still not going to let you have a second bite at the apple because we're basically only going to look at the consolidation laws and elevate those and say that controls, period. Even though we're saying we read them in harmony, I don't think it does. But let me ease your pain. Let me wrap it up since we're well into the lunch hour. I seldom get to have sort of this kind of intellectual discussion about these things. This one really begged for me that we have a record made. I am ultimately going to retain the case. I'm ultimately going to retain the case because I think that we have to look at the very plain, very broad, in this humble court's opinion, overly broad and poorly worded rule 48.1 subsection 9, which does in fact say that in the event that the action is reassigned for any reason other than exercise peremptory challenge, you get another peremptory challenge. I think that the rule, it was intended to apply to give a second peremptory where the court administratively reassigns for court administrative functions and that list of reasons and other similar reasons. And at the end of the day, I do believe that this is a case, I'll just harken back to the beginning of the discussion. I don't believe this case is properly designated for business court initially. However, it went to business court. There was a peremptory challenge exercised and that went to another business court judge who made her decision that it did not belong in business court, chose to use the language in her order to reassign the case rather than keeping it herself as a C and reassign the case. So it was reassigned. It was ultimately reassigned, in my opinion, because it was improperly designated business court, not for reasons that should have engaged for another peremptory challenge if the rule, when its inception, 48.1 subsection 9's inception and reasoning, I don't think is applicable here. However, the rule does apply here, and in its current form, its current wording, I don't see any way, since Judge Johnson chose to, again, not keep it as a C, but instead ask for it to be reassigned. And the court did in fact reassign it, the rule applies. And I think the resolution for future cases like this lies in a revision of the rule and not the non-application of the rule here, because my perception is this is not the type of situation where it was intended to give a second peremptory. Reading the rules straight up and the way Judge Johnson de-designated it business court, but then ultimately asked for it to be reassigned, you get your second bite only in that scenario. But I was concerned, I do think in the proper course of development of the case, it should not have been filed in business court originally. If y'all ended up with whomever you ended up and wanted to preempt, that's one time. You get the second, then preempt. If somebody asked to go to business court and it was de-designated, you would have had another preempt after that. But at the end of the day, we can speculate all day long of the what ifs might have happened. We have what we have here. And I can't find any way not to apply the rule, even though I think everything in the analysis of Reggio would speak to why there can be scenarios where it's just should not be the rule application, and that it's ways in which the court transferred something that have nothing to do with the need to have a second or the appropriateness of having a second peremptory. But the way the rule is worded and the way this case unfolded, I think the state was properly exercising a second peremptory. And I think then the defense, of course, exercising its peremptory brings the case to our department and it stays. But I appreciate very much you all spending an hour with me, well, longer, since we were technically supposed to start at 10:30, but you spending an hour with me to sort of really hash it out and in the end, make the record. Because if there is potentially going to be a rule change, it might very well be this record that helps the appellate court or the Supreme Court, who will, look at the rules and whichever group is ultimately fashioning, the rule changes to see what occurred here. And is this rule too broadly worded for what was actually intended?
Well, Your Honor, I appreciate that. I appreciate you allowing me the opportunity to make my points. And we weren't really aware of this being the problem that it obviously is, this overuse or over designation of business court cases. But this has been helpful to us because I can assure you, we're going to be much more careful in the future, having become aware of this because of the situation with Judge Johnson.
Well,
I can designations in the future so that we are very careful about looking at the case, looking how it 1.61 applies, and making sure to give the court better information about whether or not the case should be in front of them in business court.
Definitely want to make sure that you give that information, or it's clear in your, if it's going to be your complaint in which you're seeking it, or if you're going to be making the motion. I would just tell you this, I don't think that there is any consensus among the business court judges, and I still retain a status as the alternate business court judge, and I do the business court settlement conferences, but I'm not technically assigned new cases for business court at this current time. But at the end of the day, I don't think that there's a consensus. That they're going to start independently reviewing these things and kicking things out of business court. I don't know what Judge Johnson's intentions are, but at the end of the day, I think the standard practice right now is probably going to remain what it has been for years, which is if somebody has to be in business court, you're there because the clerk's office is going to put it there. And it's going to be up to somebody in the case, if they don't want to be in business court, to make that ask, at which point it will trigger the review of the business court judges to make sure it belongs there. And hopefully then they would apply the rule and do what they needed to do. But I don't see it being a situation now, just because Judge Johnson did this in this case, that you're going to see all the business court judges all of a sudden now start, scrubbing their cases of things that they don't think belong there, or sua sponte reviewing new business court cases to make sure they belong there. I don't see that happening. I think it's going to still be driven by, so we say, the complaint process of, I don't think this belongs in business court.
Well, and you're probably right about that, but it's still, to me, from my perspective as a practicing lawyer, I think it's my client's interest to, now that this issue's, we become made aware of this issue, that certain judges, even what the judges consider, because we've been going on that form and clearly that's not an appropriate thing to do.
That's going to have to change regardless. And I don't know if that has already been something put on the radar, but there should be nothing that indicates that it's proper to be in business court because of complex case management.
We'll do it on our own, but I also agree with you. I think that, and again, I had thought about this until this came up. Supreme Court does need to give us all some more direction on what their intent was here, because you know, then we can avoid.
Yeah.
And I agree with you. It's not often I get a chance to have a conversation like
That
this
was
with a
fun.
judge. I do too. I used to do this with Judge Earl, and sometimes we go on, everybody else in the courtroom looking like, you guys shut up and sit down.
My very first criticism when they used to do those, I'll say god awful, RJ anonymous survey things was, oh, Judge Delaney seems to think it's way too fun to make these arguments like she's some kind of law professor and we're all sitting here having to bill our clients for her having her little romps with the attorneys and their things. And I was like, oh, I do that. That's not okay. So I stopped doing that. So it was a good criticism.
You mean
Well-
judges read those articles?
Well, we tried not to.
I don't blame you.
Well, but at least only your staff has been penalized by our conversation. At least we've got other lawyers that are sitting here and waiting. for their case.
Well, Mr. Busquezi was along for the ride too, but hopefully it all was beneficial in that we cleared it up. We made I think a solid record and we'll see what happens. I don't know what's going to happen next with the rule, or I think certainly the civil cover sheet will change. But I think everything remains status quo with business court. So do what you're going to do, let the judges do what they're going to do. And in the end, if somebody challenges it, that's what will trigger the further review.
Your Honor, should I do a fairly detailed rule or order, and obviously I'll pass it by Mr. Pugliese, but if you want me to do that for the record, I can do that. I'll get the transcript and we can do it that way. Or if you want it to be simple, whatever your preference is.
No, I think the court will issue the order. I don't think we need to do anything specific. I set the order to show cause. I'm just gonna make the findings here today that I have in the minutes that this, in the end, was not an improper second peremptory challenge, that based on the language of the rule and the way it occurred in this case, for Judge Johnson to reassign rather than retain the C designated case, that you were invested with a second peremptory and the case is properly before the court at this time.
That's even better. Thank you.
That's basically the ruling.
Okay.
All right.
Thank you.
Everybody have a great day.